going to give you a general feel. It is not teaching, it is to give you a general outlook of the law of contract. So in your reading, you will discover that contract has been defined as a promise or an agreement between two people that contains promises. I will do this, you will do that. And that promise or that agreement with a promise is legally enforced. It's legally enforceable by the law. So if somebody does not hold to their end of the promise, then the law will hold them accountable. So people who agree together in an agreement, people who come together and agree together and give each other promises, they create for each other duties and responsibilities. Those duties and responsibilities are enforceable by the law. It is between two people, two or more people. These two or more people are called parties. So when you come across the term parties, don't worry. It's a term that is used to describe those who come into an agreement, and this agreement that has promises that are legally enforceable. So you can define a contract to be an agreement between two or more people, legally enforceable by the law, that creates rights and responsibilities for the parties. Now, you will go through the topic of what makes a valid contract. So for you to answer the question, what makes a valid contract, you need to look at the essentials. What are the essentials of a contract? Number one, offer and acceptance. There must have been an offer and somebody must have accepted it. An example would be an offer that says, I am selling a bottle of water at 50 shillings. That's an offer. An acceptance, on the other hand, is this: give me that bottle of water at 50 shillings. Okay, so there must have been an offer and another person, one party made an offer and another party made an acceptance for there to be a valid contract. Secondly, we have what we call intention to create legal relationship. Like we started by describing, a contract creates obligations and obligations or duties and what rights. So if I promise you to sell you a bottle of water at 50 shillings, I am one party and you are the other party. You accept my offer and say, fine, I will buy it at 50 shillings. Then I have promised you to sell it to you at 50 shillings and no more. And I have promised you to sell you good water and not bad water. So I must have had the intention to bind myself legally, okay? So that if I don't sell you that water at 50 shillings, or if I sell you that water and it happens to be, it is of bad quality and makes you sick, you can sue me legally in court. So I must have intended to enter into this contractual obligation kind of situation with you. So each party must have had what we call the intention to create legal relationship. Thirdly, there must be a consideration. Consideration is mostly it is not only consideration includes, if I am going to sell you a bottle of water for 50 shillings, the amount of money that you pay me, 50 shillings is a consideration that you give to me. So for any contract that we enter into, there must have been a consideration. Sometimes a consideration can be money, like in that case 50 shillings. Sometimes a consideration is something else that is not money. You will come across scenarios where consideration is something else other than money. Even the word promise to sue can be a consideration, or promise not to sue. For example, I can say, I will supply you 500 bottles of water if you promise not to sue me. So in that case, the consideration is the promise not to sue. Capacity. The law says for people to enter into a contractual relationship, they must have the capacity. And capacity, when the law talks about the capacity, it talks about they must be above the age of 18. In Kenya, it is above the age of 18. Or they are not persons of unsound mind. If they are a person of unsound mind, that contract is not valid. If they are below the age of 18, that person is a minor and that contract is not valid. However, there are exceptions. That is just the general rule. There are exceptions, as you will find in the reading material I have supplied. Fifthly, there must be consent or free will. I must give you consent. It's not when we enter into a contract, I must give you free. You have the choice. you have the will to enter or not to enter into that contract. So if you have been forced, it is called coercion. So if coercion happened, if somebody made you enter into a contract by coercion, then that contract is invalid. The subject matter of the contract should be lawful. That means the contract itself should be made. If I'm selling you the bottle of water, that bottle of water is the subject of the contract, and that subject of the contract must be lawful. We cannot be entering into a contract for illegal things in Kenya. So we after looking at the essentials of a valid contract, we will look at classification. How do we classify contracts? Contracts can be express or implied. If we express it, it means we either spoke about it or we wrote it down. That is express. Implied is you can tell from my actions that I wanted to enter into a contract with you. It is implied from the actions. It can be unilateral or bilateral. A contract can be unilateral. If it is unilateral, it means it has only one party. If it is bilateral, it means more than one party, 2 or above. An example of one party is a case of Khalil versus Carbolic smoke balls. Please read on that. It is in the reading material I have supplied. I know you will come across it. Mine is to just explain briefly what you will find in your reading material. Thirdly, we have valid, void, and voidable contracts. A valid contract is a good contract. Okay, it has every essential that we have mentioned previously of offer acceptance, intention to create legal relationship. All those essentials are there. Then that is a valid contract. If one of the essentials is lacking but can be supplied within time, it is called a voidable contract. If we entered into a contract when you were 17 and a half years, then we discover it when it's 4 days before your birthday and you actually turn 18, then it is a voidable contract. We are to void is to spoil. To void is to make bad. To void is to make non-effect. So the contract is capable of being voided, but it has not been voided yet because there's a factor that is missing and we will replace it. If this factor that is missing, if this element that is missing can be obtained and we obtain it, then that is a voidable contract. A contract that is not void yet, but it is capable of being voided. Then we have void ab initio. What we call it void ab initio. Void from the word go. That is a contract where when we entered, if I entered into a contract with a person by coercion, very void contract. If I entered into a contract with a person who is a minor, void, unless that minor has turned 18 or is turning 18 in the next 2-3 days. I hope you understand the difference between a void, avoidable, and a valid contract. Then we have specialty contracts and simple contracts. You will come across that in your reading material. We have contracts that are contracts uberimae fide. That means contracts of utmost good faith. And an example that I will give you is insurance contract. Here you must disclose everything because it is a contract of utmost good faith. The best example we can use there is a contract of insurance. Then we have contracts of partnerships that is made between partners. We said there are very many ways of doing business. You can do business as a company. You can do business as a partnership. When people do business as a partnership, they have what you call a partnership deed. In that way, they will have a contract of partnership. Then we have contracts of records, executed contracts, executory, and quasi contracts. You will be able to read all of that in your reading materials. Then, after looking at what makes a contract valid and what are the ways to classify a contract, we look at how to form this contract, the formation of a contract. The formation of a contract, we will study each element keenly, one by one. And then we will look at the terms, these promises that they make to each other. We have express terms and implied terms, and then we will have conditions and warranties. Those ones I will tackle in our next video. Then after we look at the terms of a contract, we will also look at vitiating factors. Vitiating factors are the factors that make a contract void. What are the factors that make a contract voidable or void? Then we will look at how to discharge yourself from the contract. After you have finished your part in the contract, then you're discharged from it, and many other ways to discharge yourself from the contract. Then finally, we will look at what happens if somebody breaches the contract, our agreement. If somebody does something that is inconsistent with our agreement, what happens? Then we will look at the remedies for breach of contract. For any questions, queries, or clarifications, kindly reach me on my available mobile number. Yes, I hope you learn. Please read on the reading material I have just sent you. You'll be sure to do well. Thank you. Have a good day and take care.